Good morning. Thank you for joining our live webinar, live Q&A with myself, Advocate Mohammed Abduroaf. And today we're dealing with those questions that people pose when they registered for the specific webinar. So we all know the way to do it is either live now via Facebook Live, the Advocate Mohammed Abduroaf Facebook page. I'm keeping an eye on that page. Alternatively, you can pose a question before the time whereby I will paste it onto the whiteboard in front of you, the Microsoft Word document, and at the same time you would be able to partake in the answering of that specific question. So if you register, you will receive a link or an email afterwards with a Zoom link for the specific time where I shall deal with that specific question. So those are the options, and if you look below the screen, those are the various other options. So that's wonderful. I have somebody online via Zoom. You're welcome to unmute yourself and chat to me and pose specific questions. Alternatively, you can just raise your hand and I would be happy to speak to you and chat to you about it. It will obviously be somebody that registered prior to that. So if you are online and if you're on the Zoom line and you want to pose a specific question to me, feel free to do so, and by unmuting your microphone or send me a message, whatever you feel would be best for you. Nonetheless, let us deal with the question that were posed. Question number 1. It's basically a statement. It says the following: custody issue of 3 minor children, parental alienation, and biased social worker and psychiatrist. Okay, so it seems to me this person has serious challenges, problems with, firstly, with the issue concerning parental alienation and a biased social worker. I presume the social worker is more finding in favor of the other party, and psychiatrist, same way, same scenario. Psychiatrist is now finding in favor of the party, more biased, not necessarily finding in favor, but more leaning towards that side, for lack of a better way of saying. Finding favor might be a bit too much to assume. What advice do I have? Remember, the courts are not bound by the decisions of experts. There may be various experts. There might be a psychologist on the one side, a psychiatrist on the other side, a social worker on one side, a counselor on the other side. And obviously, under those circumstances, the court will ultimately hear what they have to say, apply its mind. The court is not bound by that, and the court will take the advice. The same way, when you argue matters in court, us as advocates and attorneys, when you argue matters in court, the court are not bound by our legal arguments, although we're the lawyers, we present legal arguments. The court is the final decider. But nonetheless, the challenge you have is, unless you can prove that there has been some biasness by the social worker, the psychiatrist, and you can prove that there has been parental alienation and show the court that these experts are not picking up on that, that could obviously be very difficult for you to do so. Generally, the way to deal with these type of matters are, if those experts finds or makes a certain decision, and based upon their experience and their knowledge and their wisdom, after consulting with the various parties, they come to that specific decision, and you are unhappy with that decision, you would need to obviously argue against it, but at the same time obtain a second opinion on the matter. Remember, you're not a psychologist, you're not a psychiatrist, you are a party to this matter. So you have a vested interest in your favor, not necessarily in favor of the other party. Therefore, when it comes to experts, and you disagree with the expert on the other side, you need to obtain the services or enlist the services of an expert to hopefully find in your favor. If that expert does not find in your favor, you can still persuade or try to persuade the court that the court should at least make a determination in your favor. And it happens many times. I've argued many matters in the High Court whereby the court did not take the view of the experts. And I dealt with a matter recently where there were quite a few experts on board, and the court went totally against all these experts' recommendations. It happens, the court ultimately have to make a decision. But nonetheless, generally the court would be swayed by experts, not by lawyers, because we are lawyers, we're not psychologists, we're not psychiatrists, we're not counselors, we are not experts regarding the psyche. We're just legal guys. So I hope that assists you in your answer. Either you attack those reports and you explain to the court why the court should not accept it. Alternatively, obtain an expert that you trust, and hopefully that expert will find in your favor. If that expert does not find in your favor, then you will have to argue harder. Okay, let's deal with the second question. The person on Zoom, please send me a message if you want to and advise me which question you posed. I would be happy to deal with you then. Okay, let's send a message to the person on Zoom. Question number 2. This question is also from Gauteng, and I think question number 2 and the third question are interrelated or from the same person. I'm just presuming so based upon the content. I would like to know, what can I do if I had a maintenance court hearing and the mother told the magistrate that she used the money I paid for the child for her brother, but still court granted her an increase she demanded. There is even on her bank statements proof of e-wallet, hence she couldn't deny. So the mother used the maintenance money and gave it to her brother. So that's the complaint the specific person has. And I presume it's the same person, so I will deal with the third question as well, and I will deal with them together. I have a baby mother who is extorting money using my child, and evidence is there in one of the court hearings. I asked based in her bank statements. While the e-wallet was sent to her brother, she claimed her brother was sick. It is not clear evidence to claim abuse of my money. She claimed 6,000 rand per month for a 3-year-old child. There is other evidence that was deliberately ignored by the court, where she is abusing the money and buys expensive Woolworths when I asked why not Shoprite. No answer, and magistrate ignored all of that. So I presume question number 2 and question number 3 is the same person, or at least the facts are more or less the same. Please note, people type on our online platform via their cell phones, and we try our best later on to edit the content to make sense. There's a lot of spelling mistakes, a lot of grammar issues, and we try not to obviously change the theme or the flavor of the question. That's why when we read it out, when you look at it on the whiteboard, it has been changed much more better than it was before. We do not want to completely change the question. That would be unfair. So we have 2 scenarios over here. The first situation is the father is unhappy with the fact that the mother used the maintenance that he paid and gave the money to the brother. And the second obviously would be the amount of maintenance that he paid, and maybe the maintenance court is not taking note of that. It's difficult for me to give an opinion without, maybe I should deal with both sides of the story, or give you my frank answer to this. Obviously the mother is spending money on maintaining the child, obviously. So if the mother is paying towards the child's schooling, clothing, the child is 3 years old, but clothing, accommodation, food, etc., she's using money on that. Now the maintenance comes into a bank account. She spent already money on the child for the month. For the specific purposes, she took that money and she transferred it to her brother. The law does not specifically stipulate that you should only use that specific money. So in the sense of a mother or a father who's caring for a child may not use their own money first to pay for certain expenditure, like rent. So for argument's sake, the law doesn't say, for example, if the rent is 1,000 rand for the month and the father's contribution is 300 rand, the mother cannot pay the full 1,000 rand on her own and later on take the 300 rand from the dad and use it for herself, perceiving that she has already paid for the accommodation. So the law does not expect that for the mother to first pay two portions, first the 700 rand and then the 300 rand later by the father, which the father contributes. The law is reasonable. The mother can pay the complete 1,000 rand out of her salary. She can pay for all the child's schooling, etc. And then when the father pays his maintenance, she can just top herself up. We all know how maintenance works. Maintenance basically is in advance, so you do not first let the child live and then later on you pay the maintenance. So if you first give the child the money, and then that specific money gets used towards the child's maintenance. So I'm not seeing much queries in these questions regarding whether or not the person is stipulating the child actually cost 1,000 rand. That's point number one, and I am paying 2,000 rand maintenance. Therefore, I'm paying 1,000 rand too much. If that is a query, it's very important that you should relook it and take it to the maintenance court. But it seems to me this person has an issue with the fact that he pays maintenance to the mother and the mother pays the maintenance to the brother, or paid it once to the brother. But then the question was, how did the child survive for that month? Obviously, the mother had to maintain the child. So when the court made the maintenance order for 6,000 rand per month, and I'm presuming I do not have any other information, is the court had to make a maintenance order going forward. So maybe for the last month, yes, the mother used the 6,000 rand the father gave towards to her brother, but she also used her own money. It could have been more than 6,000 rand towards the minor child. And the expenses of the minor child going forward is 6,000 or 7,000, 8,000 rand per month, despite the minor child being 3 years old. I'm not many children of 3 years old cost much more money. Some cost much less money, depending upon the circumstance of the family, the accommodation they have, standard of living, the schooling, the creche, clothing, daycare, and so on. So each case is totally different. Therefore, it is difficult for me now to just presume that 6,000 per month is too much or is too little. I do not know. But the bottom line is the law does not expect the mother to first take the maintenance from the father, use that maintenance for the child. The court doesn't expect that. What the law expects the mother to is to adequately maintain the child, look after the child, and for both parents to maintain the child based upon the parents' means. So, not to confuse anybody and everybody or whoever's watching this video, if the maintenance court determined that the child cost, for example, 8,000 rand per month and the father's contribution should be 6,000 rand per month, that is perfectly fine. The court can make such an order, and if the mother receives the 6,000 rand per month, because the child costs 8,000 per month, we know that. And if the father pays the 6,000 rand per month and the mother decides to take that 6,000 rand per month to give it to her brother, that is perfectly fine, as long as she still spends 8,000 rand per month on the minor child. I hope that answered that specific question with the data I have in front of me. But at the same time, if you are unhappy with the decision and the magistrate made a mistake or erred in it, you are welcome to obviously appeal it, and a higher court will relook this entire matter. But we're not here discussing that specific scenario. Question number 4. Okay. I have a live question on the Facebook Live. I shall deal with that accordingly once I'm done with question number 5. Question number 4. Me and my minor child were forced out of the marital home by my husband after he beat me up and threatened to set the house on fire. I still have access to the house but want to move back because my children are not happy where we are currently staying. He filed for divorce and lied. So I want to contest since I was the only breadwinner for 3 years of marriage and he didn't contribute to anything. We also have interdicts against each other. Okay, so first things first, you would like to go back into the home. I cannot see any reason why not. And if he wants to burn the house down, I don't know if he will do that. It's most probably a threat he's making. Obviously, it's a criminal offense. You cannot burn people's houses down. I see they have interdicts against each other, so it seems to me that the court has dealt with that scenario already. So regarding the divorce issue, obviously if she's contesting the divorce, she needs to oppose the divorce. I cannot take that anywhere further. and ultimately the divorce court will make a decision as to what should be the outcome of the situation. I would obviously would have advised the mother, the specific person here, to go to the domestic violence court and obtain a protection order limiting the father from this emotional, psychological abuse. But it seems to me they have been there. If the protection order was granted on a different basis, then I would advise you to approach the court again and ask them to relook the matter and ask them for protection order on a different basis. But regarding the divorce, my advice to you is defend the divorce, obtain the services of an attorney to assist you regarding that. I hope that assists you. But you're welcome to, that's why we have the option of the Zoom. You're welcome to interact with me and ask me questions if you are online now. And the last question before we move on to the Facebook Live question. The father of my kids intimidated and insulted me in front of the maintenance officer during informal inquiry, and he was never called to order. The maintenance order was made on that day. I have applied for a substitution or increase, and we will be going back in January 2022. I'm not sure if I need to have an attorney to represent me in the magistrate's court, or the magistrate will deal with the father. I can't stand the father's attitude, arrogance, and stubbornness. The father makes me feel small. For me, he is more emotional and psychological. All I want is a fair maintenance order. I basically see the issue concerning, the father or the ex-partner belittling the person. That seems to be the theme happening here. It should not be the case. The maintenance order was made on the day, so I do not know how that was made. Was it done by agreement, or was it done by after a formal inquiry, a trial where evidence was presented? I do not know, but the bottom line is they are approaching the maintenance court again in January 2022 for a substitution or increase. So they want to she wants to change the current order. My advice to everyone is, if you ask me the question, is it best to have an attorney? It means that there are issues involved, and I would advise you, if you can afford it, make use of a legal representative to represent you at the maintenance courts. It just makes logical sense. You can do it on your own, you can attend to your matter on your own, but if you ask me a question, what's better, fixing your car yourself or getting a qualified mechanic to do it? If you are a mechanic, wonderful, fix it yourself. But if you are not a mechanic, then obviously it makes more sense to have a mechanic attend to it. Alternatively, you have to get manuals out, books out, YouTube videos, whatever the case may be, to figure out how to fix your car. That's one way of doing it if you cannot afford. But however, in our scenario, and looking at your scenario now with all this abuse, emotional, psychological abuse, it may be a good idea to enlist the services of an attorney to assist you at the maintenance court. And you do not have to deal with the father at all. Only the attorney will deal with the father. So I hope that answered that specific question. The person on Zoom, you're welcome to unmute yourself if you have any specific questions. Otherwise, please remain on the line. Okay, so here I'm copy and pasting the Facebook question. Let's get to that. Yes, so the Facebook takes us to the next page. That's great. Okay, the Facebook Live question, thank you. I see the person is still online. If the person paying maintenance deducts from maintenance, could I go to the maintenance court and pursue a breach of our divorce agreement? Now, first and foremost, parties needs to comply with the exact terms of a maintenance order, unless there is some type of an agreement to waive it. For argument's sake, let us say the maintenance order says both parties should pay 50% of the school fees, and the mother should pay the father 5,000 rand maintenance in cash. So the father's obligation is 5,000 rand maintenance in cash, and half the school fees, for example, 2,500 rand per month. I'm just making simple numbers here to demonstrate a scenario. However, the mother will advise the father, why must both of us pay every month, go to the school and pay 2,500 per month? Why don't you, Dad, have a debit order done, deduct 5,000 from your bank account every month, and just pay me the 2,500 per month? If that is an agreement and the parties are happy with it, wonderful. I'm happy with that. Have it written down. Should there be a dispute in the future, nothing bad will come from that, because the father can show the maintenance court, this was an agreement we have. I still paid my full 7,500 and maintenance, my 5,000 in cash, and my 2,500 towards the school fees. But the only difference now is I paid the 5,000 towards the school fees, and 2,500 as cash. Is the same thing. The mother does not lose out 1 cent, or the child does not lose out on 1 cent. However, if there is no such agreement in place, I advise each party to stick to the letter of the order, the maintenance order. If either party is not happy with that, if one party wants to decide, I want to pay for something, I want to pay for that, and then I want to deduct that from the other party, don't do it yet, at least. Approach the maintenance court. Make an application for the substitution of the maintenance order, and you have to explain to the court why that would be best under the circumstances. Remember, the primary caregiver, the person caring for the minor child, knows exactly what is needed in the house. You cannot decide to buy a kilogram of potatoes every second day, but maybe the mother is not making potatoes, or maybe she has potatoes, or maybe there's too little potatoes in the house and she needs more potatoes in a kilogram. I do not know. But you cannot make that assumptions on someone else's home. And then you want to deduct. So the mother bought, for example, a big box of potatoes of 100 Rand. And you now decide that you want to buy potatoes at a more expensive place. You're spending 120 Rand. And now you want to deduct 120 Rand from that amount. It doesn't make logical sense. That's the reason why we have a divorce order. You stick to the divorce order or the maintenance obligations in terms of the order. If the questioner now, the live questioner on Facebook, what can you do? Yes, I would advise you strongly lay complaint to the maintenance court for non-compliance with the maintenance order, because that specific person is not complying with the maintenance order. So you have a recourse regarding that. It is a breach of the agreement. It is a criminal offense not to comply with the maintenance order. And I have an additional comment from the specific questioner. Let me just copy that on. Okay, there it is. And the second part of the question is, it's my son's maintenance, he's deducting from money I owe him. Yeah, so those are separate issues. I do not think it's not, firstly, not that I do not think, it's not a valid defense. If you owe him money, he should take you to the civil court, get a summons issued against you. If you do not pay, obtain judgment, and he can execute a judgment against you. But the maintenance is obviously for the minor child, and he has an obligation to maintain the minor child. Therefore, he cannot offset the maintenance on any amount you owe him. It's two separate agreements. This money is for the child. And if you do owe him the money, he has recourse on other civil remedies, as I mentioned earlier on. One being the civil remedy, either issuing summons, taking to the small claims court, whatever the case may be. So I hope that answers your specific question, and hopefully you can resolve this matter with him as soon as possible. But you are still, despite you owing him money, you still have a case to approach the maintenance court for him not complying with the maintenance order. Okay, I think that is it. I see no further questions on the live. I think the Zoom person does not have any questions. I think we've done well today, and hope to see you online again soon. Have a lovely day. Thank you very much.